Just comb your hair, go and wash your face. It's been a real long time since you've seen the light of day. So let thoughts come as they may, beauty and parade. Everybody all smiles when you're back in the seat again. All aboard the Petty Express to a beautiful darkness. It's full steam ahead to ride the rails to our next destination. Yeah!
Well, good evening, everyone, and hopefully we will get this last little appendix of day 2 done, and then I will do a little breakdown video of day 1 and day 2, hopefully tonight. If not tonight, then early tomorrow morning, and we will be ready to roll into day 3 on time. It's a Lenten miracle. Don't expect any more. Welcome JKD Buck and Rachel D and Tammy. Welcome, welcome. So we are still with Amy Elizabeth Darling. She was the former Van Buren County. No. So she was the former Van Buren County medical examiner investigator. So she would have been the actual person out on the scene collecting, the clothing of Todd. So maybe we'll learn where the sweatpants and socks went. She would be the person, saying, hey, given that the body was found here, we should probably take photos here and here, just because he was moved, maybe if you can give me an approximation of his original spot, and then where they put them. And welcome 80s Music Man and DK Cripple. So that is kind of where we are. This is, I do believe, the state still, and then we'll get to the defense. And then I believe we'll get started on James Shinsky, the fire investigator.
Jackets and blankets were set aside. The decedent sheriff's department, but I'm not for sure.
Were you present when they were taking the photos?
No, ma'am, I was not.
Okay. And you mentioned that there were several articles of like clothing laid on the decedent?
Yes, ma'am.
And what is done with those items?
So the articles that were covering the decedent's, most of his body, the jackets and blankets were set aside. The decedent had socks, underwear, and sweatpants that were on. The underwear and sweatpants were collected by the fire marshal who was on scene because they had the odor of accelerants on them.
And then what happened with the other items?
The other items are left there for the police officers to either take with or they're discarded.
Do you recall what items then went in the body bag then with the body?
The pair of socks is the only article of clothing that went with them.
Was there any of the items that were thrown on the body that would have gone in that body bag?
Not to my knowledge.
Okay. If somebody were to have put one of those items in, a shirt, would you have known about it?
I would have seen it.
And you did not see a shirt?
I did not recall seeing a shirt.
Okay. And you said that a few of the items then were taken and released to then, who?
The fire marshal?
The fire marshal.
Michigan State Police Fire Marshal.
And do you know who that was?
That was Sergeant Leroy.
And then did you do anything else on scene?
No, ma'am.
So once the body's taken away, then did you just leave?
Correct.
Okay. I have no further questions, Your Honor. Thank you.
Okay, I think it's the, oh no, is it the slow man or the aggressive dick?
Doctor, I'll start out with a simple question.
Aggressive.
You don't know what caused the fire in this case, correct?
No, and I'm not a doctor, sir.
I thought you said you were,
A medical examiner investigator.
my fault.
Nope,
Sorry.
that's okay.
Okay. You don't know what,
She does this weird thing when she smiles. I've never seen anyone smile and then their lips pull down. Because she looks like she's happy. I mean, her eyes are all sparkly, so she looks like a kind of jovial type person. But when she smiles, it goes down, and I've never seen that. Anywho, ADHD moment averted.
what caused the fire or where it started, correct?
Correct.
Okay. Let me back up a little bit. When you come out, do you have like a notepad or a binder where you're checking off stuff? How do you keep track of what's on a body at a crime scene?
What's on a body at a crime scene?
Like we had clothes here, you're responsible for making sure things get to the medical examiner's office for an autopsy, right?
Correct.
Okay. How do you document what's on there so you know?
I write a report.
And you wrote a report in this case.
I did.
In this particular case, you said Sergeant Leroy took the sweatpants and the underwear from the scene, correct?
He took them from the decedent as evidence.
Did you see him do that?
Yes, I did.
All right. Did you, obviously you authorized him to do that?
That is part of the investigation, correct?
What if that's considered evidence? It might be a possible crime, right? You understand that?
Correct.
All right. Why is Sergeant Leroy taking evidence from a possible crime scene without?
He's I thought the state police fire investigator. Would he not be the person to take fire investigative-y stuff? I mean, I get what he's getting to, and, the fact that if there wasn't an exact paper trail, we are going on these people's words of mouth. I get that. But does he have to say things so intrinsically dickish? Like, if Dickanese was a tone, he would be a scholar in Dickanese. I'm trademarking that. I see you, Disney. I'm trademarking it.
The body first going to the medical examiner's office to determine what relevance it might have.
Sir, that would be something for the fire marshal. I don't know their protocol. It's between them and the detective bureau.
Okay. Am I clear? And you work for Van Buren County?
I worked for Van Buren County Medical Examiner's Office.
Okay. At that time?
Correct.
Did the Van Buren County Medical Examiner's Office have any kind of a policy, written policy regarding allowing evidence, clothing, whatnot, to go from a crime scene without being okayed, or strike that, without being transferred to the medical examiner's office who's going to do the autopsy?
When it is deemed that it
Why would clothing... Okay, again, this makes logical sense. I get why he is saying, I get why he would be concerned as a defense attorney, with these disparate organizations, who's making the call, where is it going, are they all following a sort of standard procedure, are the procedures different, and different in such a way that it could tamper with evidence or contaminate something. I get all of that, but his tone is incredibly dickish, and the medical examiner wouldn't have hierarchy over, I would think, the state police in investigating a crime. I could be wrong. I, dropped out of college twice. But unlike this dick, I don't have law school, loans. So it swings and roundabouts.
it's part of the protocol that if it is law enforcement and they are taking it as evidence, not to just take it and discard it, they are in charge of that.
Okay. That is a written policy by the Van Buren County Medical Examiner's Office?
Sir, I don't have access to that. I couldn't give you the exact, that is how it was functioning.
Okay. That was the custom, is what you're telling us.
Sir, I cannot say for sure if it is in a written policy.
Or a formal procedure, it's just that's the way it was done?
That was the way it was done.
In this particular case, you need to make sure there is a chain of custody, am I right?
Correct?
So you document in your report what was taken with the body bag and to the medical examiner's office.
Correct.
Did you say there was a funeral home? It goes to the funeral home first?
It's transported by a funeral home. I don't have the ability to transfer a body in my personal car.
Okay. So a funeral home gets contacted, hearse or something?
Correct?
All right, then they take it to the medical examiner's office for an autopsy.
Correct.
Where else are you going to put I mean, I'm sure Amazon or the local ice cream truck isn't going to let you just, haul it. Okay.
Anything else that you remember that Sergeant Leroy took?
No, sir.
How many, this is 18 years ago, how many scenes have you been to in the course of your career?
Sir, I couldn't tell you.
Countless, right? And yet you remember the odor of an accelerant on this particular body 18 years ago. Is that right?
Correct?
And in your report, that would have been important, right? Mm-hmm. Yes?
Correct.
Did you write that down in your report?
I did, sir.
Can I see that? Do you have it in front of you?
Would you like me to show you where, sir? So you don't have to search around?
Take it, thank you.
Bitch, you go, girl. And I mean that in the most empowering, not third wave feminist way, but oh my God, ma'am, you are allowed that smug look. Yes, ma'am. We're gonna baconate just a little bit because this man has been an utter asshat for the last 2 days. And this woman had her thing. She's like, no, sir, I have it highlighted right here. So, and her folder matches her shirt. Snaps, 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 snaps. TK Cripple, it's so weird because her eyes are so sparkly and lively and happy looking. And it's almost like when she smiles, they go down for some reason. I don't know.
Would you like me to show you where, sir? So you don't have to search
I'll
around?
take it, thank you. And once the fire marshal was present, you were letting him take over in terms of whatever, and this would be Sergeant Leroy, thought was relevant, fair?
Negative, sir.
Okay.
I'm in charge of preserving evidence on the body. If he had something that was on the body, or one of the detective bureau had something on the body that was deemed as evidence, they could secure that. They weren't allowed to take a sampling of vitreous humor, the fluid from the eye, or blood, or anything that pertains to changing the composition of the body.
Of the body itself.
Correct.
Okay, so in your report, one of the things you learned, you try to get the background of what was going on, right?
Correct.
And you learned that Todd Stermer, where you found him, wasn't where he originally was when the first people who came on the scene got there, right?
Correct. That's in my report.
And in your report, you said, after they moved him, they found him in cardiac arrest. They removed him from the boat and started CPR. So you learned at some point in time that there was a boat involved. Is that correct?
Correct.
Nobody told you a little 3-foot sled or anything, right?
Negative, sir.
Let me give this back to you.
Hey, Sir Dix-a-lot. I noticed you didn't say anything more about, the pants and the underpants smelling like gasoline. It is funny how you seem to have given that report back, after she was like, would you like me to point out the, paragraph in sentence? I just thought I'd point that out for no reason other than he irritates me, and I'm just glad someone put him in his place.
Was the end of your involvement when the body was transported?
Correct.
So you only had a short period of involvement, is that right?
Correct.
You took no photos, correct?
Correct.
You did write that report, right?
Correct.
Would you agree with me that chain of custody is very important in your business?
It is,
Why?
because it is a legally defensible chain of evidence.
And that's why you have procedures
Correct.
to protect that chain of custody,
Correct.
including the underwear in this case.
Correct. I wouldn't have handed it off to a firefighter. I handed it off to a law enforcement official.
Are you aware, and you're certain about your memory, right? You seem to have a good memory about it, even though it's 18 years ago. Yes?
Correct.
Are you aware that Dr. Markey testified that the underwear and socks were in the body bag?
I was not. I'm going off of what I had documented down.
Okay. If Dr. Markey testified to that, you may possibly be incorrect, isn't that right?
Correct. I'm going off of my report. As you said, it was 18 years ago.
Working for the county medical examiner's office, you have testified countless times on the side of the prosecution in cases just like this, right?
No.
Have you testified ever in a case like this for the prosecution
I have testified one prior time.
in your whole career?
Correct.
Okay. And that was for whom?
That for Van Buren County.
For the prosecutor's office.
Correct.
And before you came here today to prepare for today's testimony, I imagine you met with the prosecutors.
For about 5 minutes on recess
Okay.
while she was filling her water.
Give me 1 second, Your Honor.
Well, that's it. Acquit this woman. They met at the water fountain, obviously through the transitive property of female to female mind control. It's obvious that they, telepathied their way through this, and they had super secret female conversations that were mostly just, this guy's a dick, isn't he? Yes. Also, wink, wink, nudge, nudge. Make sure that client, their client goes to jail. Yet, A for effort, D for denied, E for excellent fuckery, honestly.
You were an investigator. You were not the head of the medical examiner's office, am I right?
Correct.
So when you get to the scene, you're talking to the law enforcement people just to get your arms around what happened.
Correct.
And that's how you got that background about the boat.
Correct.
Who determines what evidence is going to be taken with you or under your, I'm going to say jurisdiction, versus a fire marshal deciding what he thinks he needs?
That's dependent on the situation.
Let me just drop some. Would it typically be if a law enforcement officer thought that there might be a crime, he or she has the discretion to take what they want?
I do not have training in law enforcement. I don't have any say as to what I can or cannot do to assist or impede in their investigation. Mine is the body.
Yours is the body, but you agree with me that evidence on the body, including clothing, maybe jewelry or whatever, could be important evidence, fair?
Correct?
Right. But you don't have that discretion to tell the law enforcement person this goes to the autopsy?
We could discuss it, but that was not my call. My expertise is not fire marshal. I have no idea or reasoning behind why he would need those clothing or tell him how to do his job.
And you are not aware if there is in fact a written policy regarding authority to take
She just, first of all, she doesn't work currently at this particular place, nor does she remember the policy that was probably stated during 2007 verbatim. Now, if you had wanted her, or I'm guessing Van Buren County, to have produced a written standard procedure or standard operating procedures documentation, then you should have filed a subpoena ducis. It's not Nukem. I know it's not Nukem. Ducis tecum. I always call it Ducis Nukem, but I know it's not the right thing. And that's what happens, children, when you constantly say words wrong. You remember them wrong. Although I still think Ducis Nukem would have been a much funnier term. No one consulted me, though.
evidence off a body.
Your Honor, that's been asked and answered.
Just real quick,
You always
you were
lie
doing
about
this for 13 years,
Correct?
all right? You've done countless scene examinations just like this, right?
Not just like this, no.
Where you come out to a scene and examine a body.
Yes, sir.
Okay.
Amy, I see what you're doing here, Miss Darling. I get it. You have decided to go full on autist in your need for pedantic, true to word, getting nitpicky and quite literal. And I'm here for it. That is what we'd like to say is passive aggressive. And that's my favorite kind of aggressive. So you can just sit right over here, ma'am. You have a VIP ticket to the Petty Express. And you're so sweet about it, too.
And you're not aware of what the policy is. Is that
Honor,
fair?
asked
That's
and
not
answered.
asked and answered. You know, you get to one last question. And you're not aware of the policy, fair?
I do not have a written policy that was in place.
Well, there was no written policy.
I do not have it. I do not have what they have. I've not been in this field in many years.
But you had it back then.
The standard of practice.
Oh, good Lord. That's another one I have to cover. I need more hours in the day. Does anyone want to, like, start nannying for me and or get me an assistant? I mean, I don't know. I mean, not in a creepy way, but if any of you know teens that are good with audio-visual stuff, that would be awesome. But, I mean, I just need an assistant and, well, a continuous supply of caffeine. Yeah, I have heard that is going to be a train wreck.
Was to let law enforcement do their investigation.
Oh, Old Line Red, quick question. This defense attorney asshat, has been bloviating on and on about the fact that this woman can't remember if there was a written policy from 2007 as to chain of custody standard operating procedure for the medical examiner's office. Now, had he wanted to get a copy of the 2007 standard operating procedures, would he have had to do a subpoena ducis tecum? I always call it ducis nukem, but that is not correct, though funnier.
Mine was the investigation for the body and the reporting to the
welcome,
medical examiner.
Erica and
Thank you.
Alex.
You're welcome.
Thank you, Your Honor. So I want to just kind of talk to you a little bit about that chain of custody. So when you seal that body bag and you secure the zippers with the tag, and it goes to then the autopsy, it's secured, correct?
Correct.
So if Dr. Markey, who did the autopsy, opens up the body bag and documents what's in the body bag, do you have any reason to doubt that that's incorrect?
No, I do not.
And so that would be documented in the pathology report to the best of your knowledge, correct?
Correct.
Okay, no further questions, Your Honor.
No reason to disagree if Dr. Markey said the underwear was in the body bag contrary to your report.
Sir, I can only attest to what I have as documentation.
Question is, you have no reason to disagree with it, I think you said.
If Dr. Markey has that documented, that's what shows in his documentation.
Thank you.
No further questions, Your Honor.
Jury, any questions of her? No? Thank you, ma'am. Is she excused from her subpoena?
I would ask that she please be excused from her subpoena, Your Honor.
Thank you. Thank you, you're all done.
To the stand, please. Yes, I do. Thank you very much.
Oh, just white noise. Afternoon, sir. Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth? Thank you. Please have a seat. The chair is pretty clunky.
A little more leg to fit in
Okay.
there.
And then you can move the microphone towards your mouth and let us know your full name. Spell the last, please.
Name is James Shinsky. The last name spelling Shinsky.
Thank you. Ms. Ivy?
Thank you, Your Honor. Mr. Shinsky, what is your current occupation?
I am technically retired from the Raymond Corporate Investigative Services as a fire investigator. However, I'm still on their part-time payroll as needed to finish the cases that I left behind.
And how long have you been in that role?
A fire investigator.
Fire investigator.
I started my training and investigation on my first fire as a trooper in 1982.
And then when did you start then? So you were a trooper for how many years?
I retired from the state police in 2003. I was a full-time fire investigator for 8.5 years, 6.5 years running the training and certification in schools that the state police puts on for other agencies. Retired in August of June of 03, and then went to work for the Raymond Group in August of 03, and I'm still there.
And what did you do then with the Raymond Group?
Full-time fire investigator.
Okay. And so who would hire you as a fire investigator?
A lot of work, insurance companies, law firms. Sometimes we'll get, corporate jobs, product liability stuff, they need a fire investigator.
And as a role as a fire investigator, did you become involved in a fire at the Stermer residence in January 7th of 2007?
Yes.
And what was then your role with that particular fire?
Determine the origin and cause of the fire.
And were you then to interview, did you conduct interviews?
Initial preliminary interviews, general information about the site, the events of the day, do the origin and cause investigation, and at that point, depending on your findings, would be the end of my role as the origin and cause investigator.
And as part of your investigation, did you have the opportunity then to interview Linda Stermer?
Yes.
And do you recall when that interview happened?
I believe January 9th and 10th.
2 days?
2 days.
And why was it 2 days?
We started to do the interview on the 9th. She had appointments, was supposed to meet with the funeral home and other appointments. So we ended that day and then scheduled on the next day to finish the interview.
So it was kind of just a continuation.
Yes.
And you had contacted
JKD Buck. What would you think if I said Bill Murray if he didn't have alcoholism? Like Bill Murray if he lived a good Christian life. I don't know why that's what my brain is saying.
Did Linda then obviously to arrange these interviews?
That's
Yes.
good.
And where did they take place?
The first one was in my work vehicle on the property, and then the second day, I believe we sat in her car, or there was a vehicle there. We basically in the vehicle and did the interviews.
And you say driveway of where?
In front of the home.
And
The
did
lost
you request
location.
that to
Oops,
meet?
the lost location.
Okay, so you wanted to meet her at that location.
Yes.
Did you have any sort of information that from the police officers at that time?
Just the initial investigative stuff, what they had. I believe fire chief was there, talked about their response, the fire call, their suppression activities, pretty much the standard, upfront information to get started.
Was it typical then for you to do interviews in your car?
Yes,
Kind of a common practice?
that was the rolling office.
Were these interviews recorded?
Yes,
And after you recorded them, at some point were they transcribed?
yes, in our home office.
So who did the transcription, your home office?
Yeah, it would have been one of our secretaries in the investigative group.
So once they're transcribed, they're reduced to then a written transcript?
Yes,
And then did you check the transcripts against the recording for accuracy?
yes, always.
That was your common practice?
Yes.
And you did that in this case?
I did.
Pardon me?
I said, the question was who did that?
Oh, I'm sorry, you did that?
Yes,
Okay. And they were accurate compared to the recording?
yes.
I'm going to show you.
Is hilarious.
I'm going to show you what's been marked as People's Proposed Exhibit number 6. If you could just kind of leaf through that and tell me if you recognize it.
Yeah, that's a copy of the transcript on our interviews.
And can you just leaf through to the back, make sure that there's no alterations or changes?
So I can tell you right off the bat that the defense is probably going to have a big and major, issue with the fact that the recording was transcribed in-house in the company and that then the recording was deleted. Now, I will say that, it is a private company. That's probably within, kosherness for a private company. But if they were brought into, a court of law, I don't know how well that's going to stand up, or at least if the defense can do anything, to make a mountain or a molehill out of this, I'm sure he will. And I'm sure if it's, lawyer buttface, then he'll do it in the most condescending way possible.
Yeah, it looks like a full copy.
Your Honor, at this time, I had moved to admit People's Exhibit number 6 into evidence.
Object, Your Honor, on the grounds that I don't know what she intends to do with bits and parts of the transcript, but to admit the whole transcript has hearsay in it, has a bunch of irrelevant information in it. So if she wants to read question and answer, we can go ahead and I'll make my objections, but not to admit this transcript in total. We're going to go through as she reads it. That was part of my objections to the exhibits.
Do you have specific sections we could talk about?
Yes, Your Honor.
Does someone have an extra copy for me by chance?
Would you like an electronic copy, Your Honor, just for a moment, or like a hard copy?
We could do electronic copy.
Okay, thank you.
I'll email it to the court right now.
I don't know.
Can we approach?
Yeah.
Yeah, his tone is always so dickish. I mean, I get that, you're not always going to have things go your way, but you don't have to, if you don't, throw a little hissy fit every time the, state does something that annoys you, they wouldn't know that they annoyed you. And then you wouldn't, they wouldn't know that they're getting a rise out of you. But instead, you continue to, just let them goad you. He has, yeah, he really has. Oh. Well, it seems like the defense is probably going to object for a lot of reasons, especially again with the fact that they no longer have the, recording, and that you don't know if the transcription was accurate from the, recording, the, electronic recording to the transcription, because we no longer have those original recordings. And again, there was probably a lot of, hearsay and different things in there, just irrelevant things, what were you doing? Well, not more what you were doing, but like your mom and them is so and so and that kind of thing. Oh, I will have to check. Our post office has been just ridiculous here lately, so let me check.
The matter we have to address may take a while, so I'm just going to let you go home for the long weekend. And because it's a long weekend, I'm going to just remind you, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them.
I do, but I need to double check on that when I go to the post office tomorrow. Because I have only 90 bajillion things. But that is good to know, because I was going to go in and check on something. So I will go to the post office tomorrow. I do wonder if they're going to get into it at all with us, or let us hear. No, it doesn't look like they are going to let us hear anything.
Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction, as well as all of my other instructions, such as not discussing the case with anyone, including family or friends or each other, no research investigations, and enjoy your 3-day weekend. Remember, you don't have to come back until Tuesday. Directly to the jury room at 9 o'clock, and wear your badges and try not to lose them over the 3-day weekend. Thank you. You can leave your binders in your chairs.
All right. So do you guys, since I didn't realize we had that little left, do you guys want to go into the Lori Vallow hearing? The one that happened today? So let's see. I know. No, I want to actually watch the actual hearing, not your, breakdown. All right.
Any matters to address? Other than
Let's talk about some of these. First of all, for the record, I did get the defendant's notice of objection to the jury questionnaire that was filed on March 20th. The defendant was objecting to, I guess, the phrasing of the allegations that the state has made.
Well,
and
we
then
are gonna try
requested
to
that the
run
fact that
it
she
at
denies the
1.25.
allegation be bolded and underlined it in the questionnaire. I did get your objection. I guess de facto, I overruled the objection and the questionnaire went out as proposed. Next, I have defendant's motion in limine to preclude expert testimony of Daniel Coons dated March 10th. Let me ask the state. That's Detective Daniel Coons of the Chandler Police Department. Is he going to be testifying as an expert?
Your Honor, we did notice him as an expert in terms of his background and training and testifying as to trajectory. So we did that in abundance of caution, but we did supplement and provide the defense with the background of that. It was provided to the defense more than 30 days before trial. And defense has interviewed him since then.
What was the last part?
The defense has interviewed him since then.
Okay. So, Ms. Daybell, what's the objection?
So for 5 years, of course, he's been on the witness list to be a regular detective, and now he's being put on as an expert. I feel like to give his opinion instead of just stating the facts. So that was my main concern. I don't understand how the trajectory has anything to do with conspiracy, so I objected that way as well.
All right.
Because moron face, the trajectory would show that the self-defense claim that Alex Cox, tried to sell harder than Meryl Streep tried to sell that she loved Harvey Weinstein at the Oscars. It would show that it wasn't self-defense, that it was cold-blooded murder. That's what it has to do with conspiracy. Oh my God, this woman's a moron. I thought Jesus was going to help her. Jesus? Well, I guess Jesus suffers the moron. She's going to need all the Jesus we can get. I mean, really, though, does her Jesus look like happy Jesus or like this Jesus? Let me take that banner off. And guys, share out that we are covering
Has he
the Lori
testified
Vallow
in that
hearing.
regard in the past?
Yes, I believe so, Your Honor. He has been trained in that area and taught in that area. And his relevance, Your Honor, would be because the defense has claimed a self-defense claim as well. It's relevant for that.
Can the state provide me what his opinion is, and does he have a CV?
He does not have a CV. We did actually put the opinion in the supplemental 15.1 that I filed, along with his,
Okay.
I believe, background and training in that as well, so.
I guess let me flesh this out a little bit more. Let me ask the defendant, you've said a couple different things. Are you saying he's not qualified as an expert, or just that the disclosure came in late and you don't think his opinion is relevant?
Well, one, I don't think his opinion is relevant, but also the fact that he's named as a firearms expert. So I don't know if he took a weekend class and that made him a firearms expert. I don't know what his experience was with that. In his CV, it just says firearms expert. So
Did you ask him those questions? Was it you that interviewed him or your investigator?
my investigator interviewed him.
Do you know if he asked questions regarding his
I'm not
background,
sure.
training, or expertise?
Okay, so I haven't listened to that yet, so I'm not quite sure. My concern was that he was a regular detective on.
Ish, your trial happens in like 4 days. You haven't looked at the expert fireologist or fire trajectory guy? Are are you have you lost your damn mind, Lori?
On the witness list for 5 years, and then 30 days before trial, he's now an expert so that he can give his opinion. And I just thought that was my objection.
Well, if that was your basis of the objection on the timeliness of it, the state did comply with the rules as far as notice prior to trial and giving some sort of summary of what his opinion testimony would be. I'll take a look at it. It doesn't sound like we need any sort of Daubert hearing, but I'll take a look at it. So let's table that for now. Next I have defendant's motion to disclose 404B evidence dated March 14 and the state's response dated March 23. I don't know that the evidence that the state is offering to introduce necessarily 404B bad act per se, but let me hear from the defendant. You got her response?
I did.
All right. So what specific bad acts do you think should be precluded? Or were you just asking for disclosure of what they were actually intending on introducing?
I was asking for a disclosure of 404B that they planned on introducing at trial, and what I got was another theory of the case. So I didn't think that any of it was 404B relevant.
Well, I think I agree with you in so much as what was listed in their response, I wouldn't necessarily characterize as 404B evidence. But you have received that, and now
Yes, she is. She is in for life. Well, she was arguing about a witness credibility or witness slash experts credibility and expertise, because apparently there is one deputy or one law enforcement member that has been on the witness list now, according to Lori, for 5 years and only kind of labeled as a law enforcement officer. But in, I guess, 30 days before the trial, he was then bumped up to, a firearms expert. Now, the judge basically said, look, I'll look at it, but I don't see anything really wrong with this. The state did give it to you in the amount of time that's required by statute and things like that. So she's just on a vacation, but she is in for life. Now they are going back to, I guess, 404B evidence, and I guess Lori is trying to keep something out, saying that it's, showing bad, prior bad acts, evidence, and it's not fair. So let's see what this legal giant says.
now you're aware of what they plan on introducing.
Somewhat.
Okay.
Correct.
I don't think I need to make a ruling on that. If there's evidentiary objections, hearsay, foundation, those types of things will be taken up when the state elicits or attempts to elicit that information. I have next defendant's motion to exclude state witnesses dated March 14 of 2025 and the state's response, specifically defendants requesting to exclude Nancy Jo Hancock, Christina Atwood, and Kay Woodcock. The state filed a response on why. Let me just make sure I'm looking at the right one.
So now I do believe that to exclude the witnesses, what she's asking is basically there are certain witnesses, usually close family members, as long as they weren't involved or I think on the scene, that like, the lead investigator are allowed to stay in the entire trial. They're not sequestered. They're not, put, so Alice G., this is the Lori Vallow Daybell motion for her Arizona trial. Lori Vallow Daybell, you might have known her as the Doomsday Cult mom. She was both charged and convicted with the murders of her two children, Tylee and JJ, her fifth husband's wife, Tammy, and her husband. But basically, this is her ex-husband or her late husband. So she already has, three, basically life without parole up in Idaho. She will be coming back. This is in Arizona. Her fourth husband, Charles Ballo, was allegedly in self-defense, shot by her brother Alex Cox, who has conveniently passed away, who has passed away and won't be held on any charges. So basically, this is an entirely crazy case. Lori and Chad were part of an offshoot kind of LDS sect that they made all of their own. They, classified people as light and dark, as good and evil, and if you were dark, then you were a zombie, and just all the crazy in the world. Well, we weren't sure if they were actually going to charge Lori with the Charles Ballo murder case along with the Brandon Boudreaux attempted murder case because she already had the life sentences up in Idaho. But it turns out that Arizona would like to charge at least Lori with those things first. So she is going to be, she's going to be representing herself. So she has been found competent to represent herself. So it's going to be Lori Daybell, lawyer at large.
The state's going to offer some sort of testimony from these three witnesses that are going to talk about, that go toward the element of premeditation and or motive. So what is your objection specifically?
Mine, Your Honor?
Yes.
Oh, my objection was that after their interviews, after their defense interviews, that it came to light that their information came, one specifically came from Dateline, and then they called each other and their information came from each other. So
I guess I'm working a little bit in the dark. What information is that?
whatever they're, planning on testifying about, none of them have personal knowledge of any kind of crime, so.
The state's not saying they have personal knowledge of a crime. They have personal knowledge of things that may lead a jury to infer some sort of premeditation or motive. So what information is that? Let me ask the state. Or what's your offer of proof on why they're relevant?
With regards to Christina Atwood, she is a person who was present when the defendant was speaking about the victim being possessed, which goes to, again, the motive of this as well as the premeditation, and that those statements were made months in advance of the actual murder. With regards to Nancy.
So that's going to be offered as some form of admission from the defendant.
So that would be admission by party opponent, and that's personal knowledge.
Did you say that was Nancy Jo Hancock?
So that was Christina Atwood.
Christina Atwood.
Nancy Jo Hancock is the last person that saw the victim alive prior to that. What she knew about this was hearsay, but her statements to the victim of what he should do were her understanding and expression to the victim that he should tell the defendant that he had changed the life insurance policy to stop all of this from going on. So she both sees him the night before, is aware that he's there, and then she makes statements to him regarding what he should do.
Okay, and then
Kay Woodcock is the person who actually obtained the life insurance policy, which the state is alleging is part of the motive. And she also has information relating to the victim himself. There are allegations, again, of the self-defense, the use of a baseball bat, so she can provide background on the victim in that area as well.
All right. Do you want to have further argument?
Just the fact that this information that is supposed to be coming forward is not, all these witnesses are getting together and talking about all this and comparing all their notes and all these things beforehand, and then they're telling us that in these interviews. Well, I talked to her 100 times. Well, I talked.
Sure, Lori, sure. I hate to sound like Dr. Evil, but right. Yes, I'm sure that Kay Woodcock, you know, you only murdered her brother and her grandson, you know, because she biologically was the grandmother, you know, to this baby boy. So you not only murdered her brother, but her grandchild, and she's going to jeopardize the case by chit-chatting with other witnesses. Sure, Jan.
To her every day. Well, she told me this. Well, she told me that. So their information is not firsthand. These witnesses are all coming together. They're all watching everything that goes on TV regarding this, and I would like them all precluded.
Okay, well, you're always allowed to cross-examine a witness about any biases they may have about those things that you've just talked about, colluding with other witnesses. Those are all areas of ripe for cross-examination, but they're not bases to preclude a witness. The court finds that based on the state's avowal that those three specific witnesses do have some minimal, although very limited, relevant information to provide and could be helpful to the.
And what Lori doesn't understand is she hates Kay so much, she's going to go after Kay and give the state the exact, and I do mean the exact, you know, all the components they need: rage, vindictiveness, callousness, and that this was money motivated. Because what do you bet 99 out of 100 of those questions are going to be about the life insurance policy, and how dare you, you know, try to take it from a woman with 2 children. So yeah, it was bad when she had a lawyer. It is only going to get worse. And I commend Kay Woodcock for, you know, having to go back into battle with this woman. But Lori, your dad job looks terrible.
Jury in understanding the case, so the court will deny the motion to exclude the state's witnesses. Again, this ruling doesn't preclude you from any objections you may have to, if they're testifying to hearsay or something like that. Next I have, is there a Mr. Eaton here appearing?
Your Honor, Matthew Kelly, I represent Mr. Eaton.
Okay, you filed a motion over the weekend. Mr. Eaton or someone that he works with filed a motion. Mr. Eaton was, let's address that now while we have people here. Mr. Eaton was listed as a witness by the defendant. Mr. Eaton apparently is a reporter in Idaho, and based on the filings, believes he doesn't have any relevant information and shouldn't be listed as a witness. So let me ask the defendant, what relevant information would Mr. Eaton have? Why is he listed as a witness?
Well, I just got this last night, so I haven't had time to read all the things that he's claiming he doesn't. But there's several things off the top of my head that is relevant.
And what?
Right now,
What?
one of the things is it's different now, right? Because he's had this off-the-record conversation with the prosecutor, and he's kind of made himself a witness. He's kind of made her a witness.
How so?
In the sense that if this is not prosecutorial misconduct, then one of them is going to have to testify and talk about how it's not.
Let's back up. How is he
Okay.
a witness to this trial? How does he have relevant information? Relevant information means a witness has testimony that makes some fact in the case more or less likely. So how does he have relevant information for what this case is about?
Okay, so initially, when
Now, Old Line Red, I am not the brightest crayon in the book, but what the hell is this woman talking about? And does this have any basis in even a slight, like, appendage of the law? Because what the hell is she talking about? How is she going to get Nate Eaton, a reporter who basically did rise to fame for being, on the ground, basically before this case, before Lori Daybell became a, household name, Nate Eaton was the one doing yeoman's work to try to get, where is JJ? Where is Tylee? That kind of stuff out there. So what does he have to do with any of this particular case in Arizona? And how is it prosecutorial misconduct if the state prosecutor talked to investigator, a journalist? I mean, generally they have pat things that they can say, like, I can't discuss any specifics of the case because it is an ongoing, court case, that kind of thing. But let's continue to hear what this genius of, the dye job has to say.
When I put him on my witness list, my intent is because I do not know what the state is going to put on in their case in chief. And so I was calling him as a witness for the purpose of impeachment, laying foundation for interviews, rebuttal to whatever that the state might put forth, because he has interviewed almost every single witness on their witness list. And if they were to say something contrary to what they said to him on a public thing, then I would use him to lay a foundation for interviews and for impeachment. So that was my initial.
You can't impeach someone over what they said to a journalist. This woman's for real. This is not a joke. I know I'm not wrong about that, but this is making me question my sanity. You can't impeach someone based on what they said in an interview. Now, if it's contrary to what they said in deposition, then you can point out that they said something different in an interview. But why you would need Nate Eaton there is beyond me. Okay. So Lori is borrowing things from another trial. This is Karen Reed, Gretchen Moss gambit, but it's not factually similar. The prosecutorial misconduct is a gambit that was inspired by Corey Richins. Oh, okay. Well, I was wondering, I'm like, I don't think any of this goes together, but I'm not a lawyer.
In calling him, I found it funny when I read the beginning of this. He says that it seems to be clear attempt by Mrs. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. So I had to laugh at that because it hadn't even occurred to me that he wouldn't be able to be in the courtroom if he was a witness according to 615. So that wasn't my intention. It was never my intention to do that. It was just to have him on hand if we needed to do that.
All right. Mr. Kelly, right?
Yes, Your Honor.
Mr. Kelly, in theory, it sounds like if a witness said something different than they reported to Mr. Eaton at some point, I guess in theory, she's right that Mr. Kelly could be called as a witness to impeach someone, but that's only allowed after the person's confronted with the actual statement that was made, and if they then deny that statement that was made. Do you have copies of his interviews and transcripts of interviews that you might want to impeach someone with?
I've been watching most of the interviews and I take my own notes, so yes.
Go ahead.
Your Honor, two things. One, excluding Mr. Eaton under Rule 615 would be a violation of his rights under the First Amendment to attend and report on this very public trial. But more importantly, Your Honor, if Mr. Eaton were to be called as a witness, the party calling him would have to comply with ARS 12-2214, which has very stringent requirements for subpoenaing and compelling the testimony of a journalist about information that that journalist has obtained in the course of news gathering. As we state in our motion, we don't believe that there is any way that Ms. Daybell can meet those requirements, but if I would suggest that if she wants to call him as a witness, she would absolutely have to follow the requirements of the subpoena law, and we would then have an opportunity to challenge that. But we don't believe that there should be any reason for Mr. Eaton to be excluded from the courtroom.
All right. I'm just thinking through this problem. If a witness got on the witness stand and said something different in testimony than you saw on an interview with Mr. Eaton, you would then play that interview. You wouldn't even need Mr. Eaton to do the impeachment because you could impeach them with the interview by playing
Godoy.
it for them in court or something like that. So now that I'm kind of thinking it through a little more, I'm not sure.
And I wouldn't need him to lay that foundation for the interview?
I'm really trying not to give you any legal advice because you are acting as your own attorney, but if the witness admits that's them on the interview and that's their statement, that is foundation. So
He's interviewed law enforcement, almost all the law enforcement that's going to be, up here on the stand. So it's not just witnesses, it's law enforcement.
well, when I say witness, I mean generally any witness, regardless of their occupation. So I don't foresee, I see it in only the narrowest of situations where he could even be called to as an extrinsic person to testify about the impeachment. You'd have to jump through a number of hoops before that as far as presenting the witness what the statement is, and depending on whether they admit or deny that it's them on that video or interview or whatever the case may be that you're referring to.
Shaky cam.
But I'm inclined to strike him as a witness at this time, allow him to be present if he so chooses in the trial. But then again, if you wanted him as a witness, you would need to subpoena him. But at this point, I'm going to strike him from the witness list and permit him to be in the courtroom. If there's a situation where you think something has happened during the trial where you think he should be called as a witness, I guess we'll cross that bridge when and if it comes. Okay?
We could just call him up from the back?
Well, we'll address it when and if it comes, yeah.
And Your Honor, I would ask that if that were to occur, that I would be notified and given a chance to appear and be heard.
Well, everyone will get a chance to be heard if we cross that bridge. I just don't see us crossing that bridge, but I could be wrong. So at this time, it's sort of striking Nate Eaton from the witness list. He can be present if he so chooses in the courtroom.
Thank you, Your Honor.
All right, thank you. Let's go next to the state's motion to preclude media from displaying or disclosing phone numbers and email for witnesses and victims. I guess I have no problem granting this in concept, but let me ask the state, are these people going to testify, this is my phone number or this is my email, or it's going to be displayed up as part of the evidence on the screen, or both?
Your Honor, it would be both. Some people would have to testify as to their phone numbers or emails that would also then to establish the foundation of then conversations that are on text messages, emails, iCloud accounts. So my concern obviously is there are both victims whose information could be displayed up there, and I think the Constitution allows them to request that that not be displayed. But additionally, just for safety concerns, given the high profile nature of this, for witnesses who have, several of them have attempted to not be part of the media and have not given interviews and would not want their information to be out there, given that this is being live streamed, having their phone numbers or email addresses live streamed out there to the world, I would ask that that not be done.
All right. Does the defense want to be heard on any of that?
No, we agree.
So we're not actually being live streamed, but there's a 30-minute delay order on broadcasting
30
what's in the courtroom.
minute?
I already have a protective order that jurors can't be broadcast in any way. And I have an order that the feed can't broadcast sidebars that we might have. So I'm going to order that the feed also, to the extent you can see it visually on a exhibit or something, they shouldn't film someone's phone number or email. And then, I don't know if the right person's here. Do we have the ability to, does the media have the ability to bleep out or silence if someone says my phone number is 480 blah, blah, blah? We'll find that out before we start the trial, but
Thank you, Your Honor.
that'll be the order. As for anyone that's doing print or podcasts or anything like that, you're prohibited from reciting an entire phone number or an entire email. You can
I think that's in
use the
case
area code,
Lori
or you can
has
use
a,
a couple digits at whatever, at live.com, at outlook.com, but I don't want
Has
the
a
emails
spaz
broadcast
attack.
or reprinted. Let's go to state's motion to preclude Lonnie Dorkin and preclude noticed witnesses. Did Mr. Dorkin ever get a report prepared?
Not that the state has received.
Do you know?
She really thinks she is lawyer Barbie right now. She is Elle Woods in her own mind. I did not see that. Was that in the Stermer case? Or Lori, because probably fair. We should all have a 30-minute buffer just in case.
So, okay. Your Honor, most likely, we're having an affidavit sent over from Mr. Dworkin tonight. He has found a discrepancy in the information that he downloaded and the information that was turned over initially by the state, and he wants to explain what that is and how that will be relevant. So if we get it tonight, we'll forward it immediately to the state, of course, tonight. He was working on a bunch of cases, and he's doing the best he could to include our case and get it done as quickly as possible, as when he was assigned from OPDS.
Well, at this time, I'm inclined to preclude Mr. Dworkin, granted something pretty extraordinary happening. I offered you a continuance last time we were in court in order for you to explore that possibility. You declined the continuance. So it's any disclosures late at this point. I'm not going to slam the door on it completely because he may or may not have anything that actually ends up being useful. But at this, if depending on what he actually has, we can talk about it. But at this time, he's likely to be precluded as a witness because the state wouldn't even have an opportunity to have their own witness or rebuttal witness look at something prior to trial. But again, depending on what you have, we can talk about it again.
Okay.
The rest of your witnesses, we've already talked about Nate Eaton. I don't know if we need to go through each and every witness, but I think where I need to start is if a witness hasn't been served with a subpoena to appear in court, there's no requirement for them to show up for your trial. If they have been served, they would need to submit to an interview with the state in advance of their testimony. And then the third aspect is they need to have something relevant to testify about, which relevant, I told you a little bit ago, means they have a testimony that's not based on hearsay, that tends to make either a fact more likely or not. So why don't we go through, I'm trying to compare your witness list to the state's motion. Let me see here. So Nate Eaton, as of now, is not a witness. Next, we have, I don't know how to pronounce her name. Is it Viasia?
Vicia. Ita Iha.
Is this one of the ones the state was able to get a hold of?
No, Your Honor, we did call the numbers and left voicemail. I've not had any response, and it's my understanding that when I interviewed the defendant's investigator, Jeff White, he also was unable to speak with her.
All right. What about Gabriel Bonilla?
Your Honor, I had an update on that one in the sense that on Saturday, so when the state interviewed, again, Jeff White, the defendant's investigator, he had not been able to speak with Mr. Bonilla. I also called and left a message on the phone number that I received from the investigator. On Saturday, the attorney for Mr. Bonilla called me, and Matthew Ballard, who represents the Church of Latter-day Saints, he advised me that Mr. Bonilla has not been served with a subpoena, but I did not speak with Mr. Bonilla or was not given an option to speak with him.
So we don't know if that person's been served or if they have relevant information.
According to the attorney, Matthew Ballard, he has not been served.
All right.
Lori is
about-
aware you have to serve witnesses.
Why don't I just ask the state? I've got your supplemental and your other one. I know you've actually talked to a few of these people on the phone.
Correct.
Is there anyone on this list, and I'm looking at the defendant's supplemental 15.2 filed March 12, on page 2, there's a number of witnesses listed out. Is there any on this list that you have talked to that you don't object to being called?
Your Honor, I think
I
that
believe so.
there is potentially minimal relevance from Summer Shiflett.
Shizlet?
I think that's a misspelling
Oh.
of her sister's name.
Okay.
I think there's potentially minimal relevance for Janice Cox, her mother.
Okay.
Adam Cox is actually on the state's witness list, so we don't object to him. I did speak with Zachary Cox. I'm not aware of any relevance as to this case from him, but I did speak with him.
I see in your pleading that he advised you he's not been subpoenaed.
Correct. Everyone I've spoken with has not been subpoenaed.
All right.
Your Honor, our subpoenas are with OPDS right now, and they should be being issued currently. The state talks about in their response, like, the state is claiming trial by ambush from the defense. Trial by ambush. How is the defense trial by ambush when they have
Because, sweetheart, I know this is gonna sound crazy or maybe sane. I don't know. Is it opposite world for you? So saying stuff sounds crazy, crazy stuff sounds sane. But sweetheart, they need to know which witnesses you're going to be calling. They need to know what your expert is going to be saying. It's almost like, you know what? I'm sure Charles felt the same way when he walked into that house and got ambushed by Alex Cox. So, turnabout is fair play, ma'am.
interviewed every single one of these witnesses before in the last 5 years since this case started. They've interviewed every single person that has been on there. They have written, transcripted interviews and video interviews of all of these people. And so how they are relevant, these witnesses will testify if and when they are needed to add additional facts or fill in the blanks that the state will no doubt leave out in their case in chief, and they'll be called accordingly. I need them to lay perhaps foundations for evidence presented by the state. The same with Lonnie Dorkin. I need his testimony will be required if and when it's necessary to rebut digital information that the state will bring forward during trial. I feel like the state is trying to say, okay, if you want your speedy trial, guess what? We're not gonna let you defend yourself. Guess what? You can't have any experts. And guess what else? You can't have any witnesses. You can't have anybody speak in your behalf. So good luck. Have a nice day.
All right. Well, that's why attorneys sometimes take a long time to prepare for a trial, because they need to give notice of what all the testimony their witnesses are going to give. They need their experts to prepare reports.
Now, I am on
That's why your prior attorneys
1.25.
and your current attorneys were asking for more time to prepare the case. So you can't really have it both ways.
Would this be the hissy fit that because this is fairly close to contempt of court. She's got the chicken neck thing going. She's got the raisin tone, and she's got the disrespect. There's a reason I'm not a lawyer, because this face is contempt of court. It is bold, it is underlined, it is all caps. So, there you are.
Ways that you want your speedy trial rights, but you don't want to give notice to the other side of what your evidence is.
I don't not want to give notice to the other side with the limitations at the incarcerated state where I am and the limitations with OPDS of getting Lonnie Dorkin late in the game that they did. I've done everything in my power as a defendant to prepare the state and to give over everything that I could do within my power with the limitations that I am an incarcerated person at this maximum.
Ma'am, look, I don't want to throw this out there, and this is a crazy concept. I've only just thought of it. But what if there was this person, if you were incarcerated, but they weren't, and they knew all the laws, like they went to a school, like a school of laws, if you will, and then you know, they took like an exam of some sort, then you would, I don't know, have someone who isn't incarcerated who could know legal stuff and who could talk legal stuff to other people. We're focus grouping this. I don't know. But there you go. Lori, let me get on that.
Minimum security prison jail.
So when you say.
And I shouldn't be able to represent myself because of that fact?
I didn't-
Negates my constitutional right?
I didn't say that. All right. I said that sometimes there are reasons to not go forward to trial as fast as you want. All right. So when you say things like they're going to fill in the blanks, that makes it really hard to assess what their relevant information is.
They have relevant information to a lot of factors that I got in the 404B information. For example, the life insurance. My father is a life insurance salesman. He worked with Charles on getting both life insurance policies, my $2 million policy and Charles' $1 million policy. He also tried to sell my insurance policy after Charles passed away. He also told me to go to call the insurance policy and said how to do that, how to call them when you're the beneficiary. I didn't know how to do any of those things. He has relevant information to that. My sister has relevant information to my brother, Alex Cox, and the whole situation of what happened on July 11th. These people have relevant information to the state's case, what they're accusing me of. There's very relevant information from a lot of these witnesses.
So what I'm struggling with is you just saying that it's relevant doesn't actually make it relevant. It may be relevant. I'm trying to find out the relevancy. What you said about your father being an insurance salesman and selling policies, that sounds relevant. It could be relevant to me. Who's your father? I don't know who your father is.
Barry Cox.
All right.
You know, I didn't have "Who's Your Daddy" on the bingo card for this trial, but I'm here for it. I'm here for it. Did anyone have a question of Lori's paternity in this trial? If you did, I think you might already have a pre-start on bingo.
Barry Cox. It sounds like even from what you're saying, though, you're not, depending on what the state produces at trial, you're not sure that these witnesses would have relevant information. It just depends, is what it sounds like.
Whatever they put up in their case in chief, am I not allowed to try to defend myself against that?
You're absolutely allowed. I'm just trying to figure out, I'm sort of a gatekeeper and I need to make sure witnesses have relevant information. And just like you have the right to interview all of the state's witnesses, excluding victims' rights, people that can deny having an interview, they have the right to interview all your witnesses prior to trial so they can have an idea of what those witnesses might say on the witness stand.
I understand that, Your Honor.
So
They also have already interviewed all of them.
I'm not talking about police interviews or interviews that may have been done years ago. The prosecutor has the right to interview any witness prior to them taking the stand, just as you do. So I'm not sure the best way to handle this other than maybe we should take it up as we progress through the case, but
Your Honor,
some of
my-
these people may or may not be even served.
Yeah, my concern is, obviously, I have attempted to reach these people. I've made my good faith effort. I've been told both by myself in attempting to contact them, as well as the defense investigator, that they've been unable to reach them. So it seems to not be following the rules of procedure or evidence to then bring up later on if they perhaps find these people at some point, then the state can try to, at that point, preclude them. When the state talks about a trial by ambush, it is in fact that. When the defense investigator themselves cannot find these people and are still looking for them in trial when they've had at least, we'll say, 4 months to try to find them, I think that at this point, precluding them is proper.
Well, I would preclude anyone that doesn't submit to an interview with the state. I kind of want to punt this a little bit just because if there's people that don't end up getting served, don't end up showing up at court, they can't find, then we don't need to waste our time talking about whether or not those people have relevant information because they're not going to be here and they're not going to testify. So I'm putting the defendant on notice that if these witnesses aren't served, if they don't submit to interviews, they're going to be precluded. even if they submit to interviews, I may have to make a determination whether their testimony's relevant or not. So again, we're gonna, I think, have to cross that bridge when it comes. The state did say that they concede that some of the witnesses, Adam Cox, Janice Cox, Summer Shiflett, may have some minimally relevant information. The rest of these, I think we're gonna have to take up maybe on a piecemeal basis, but I don't want it, it's not gonna be a situation where you're ready to call them in as a witness.
Lisa, and the state doesn't have any requirement to find witnesses for the defendant. Now, the state can, help with certain, possible finding of them in conjunction with the police, but they are under no requirement. This is the sort of same issue that Daryl Brooks ran into with his witnesses. The state is under no requirement to help her with her subpoenas or anything else. That being said, they can out of the kindness of their heart do that. But they also have she does have a paid investigator that should be able to find these people as well. So I'm going to have to respectfully disagree with you, at least on the point that the judge can compel the state to, do anything to help Lori. They're doing this to try to make sure that this trial runs as smoothly as possible, with the show that this is going to be with her being pro se. And no problem. I mean, I wouldn't have known this except that I learned this from watching a lot of trials and things like that, but also sort of being in contact with lawyers. So I didn't know all of these things when I first started out, but there is a sort of issue with this is why it is not wise to be a pro se incarcerated defendant. You don't have access, you don't have this. This is a different, so this is the one from today. She misspelled her own sister's name. I give up.
The morning of, and then the state they haven't been presented to the state for an interview prior to that. So keep that in mind when coordinating with your investigator. If he gets them served and they're actually going to be called at trial, they need to submit to an interview in advance of their testimony.
Your Honor, I understand that, and I am limited in what I can do. If I could call these people myself, they would answer my call probably, and I could have this discussion with them, but I'm going through the limitations that I have at the jail through my paralegal who's working overtime and my investigator who's working overtime to try to do everything to help me prepare for trial, as they have other clients as well that they have to do things in a timely manner for. So
Hey, how do we end up feeling the morning after the Mo and the Drunk End stream? Well, I mean, actually not terrible. So it wasn't until the next day that the revenge came in the fact that I got norovirus. So that was always great. That being said, Mr. Mo tried to ask me something after I got off the stream, and he's like, "You did not know what I was saying, did you?" I was like, "No, but was I smiling at you?" And he said, "Yeah, you're a happy drunk, but you didn't understand, a word I was saying." And I said, "No, I did not." And I was okay with that.
we are doing the best that we can.
Okay. All right. We next have defendant's motion to dismiss for violation of confidential communication in the Sixth Amendment dated March 18 of
The
2025. and
Sixth
the state's
Amendment?
response. Let me ask the defendant first if you've received the state's response.
I did.
Did you say you did or didn't?
I did.
Okay.
Yes.
If you have an attorney in Idaho that is working on an appeal, it appears that the information that was turned over by the jail was some pretty innocuous messages about trying to set up the legal line to talk to you on a confidential line. And really, that's about it. So how does this arise to some sort of nefarious interception of things? Because it was put on a public chat system that the jail uses. You know it's not confidential. And you're told it's not confidential. And then even if I look at the substance of the messages, there's really nothing in the messages that would arise to some sort of confidential communication, just trying to set up a meeting and get the unrecorded legal line set up.
Who's saying that they're not confidential?
Well, the
Who's
jail.
telling me that they're not confidential?
The jail tells you it's not confidential. Usually it's in that terms and agreement. And you'll click on it and you'll say, hey, yes, I agree and understand that these are not confidential. You know, just like I'm sure that, you know, they have that little recording for both the prisoners and the non-prisoners getting cell phone calls or jail calls from, you know, jail. Oh, good Lord.
Your own attorney, it looks like. Here's a message. I see that they came and got you. I'm working on getting a confidential attorney line set up. The implication being that this message is not confidential. The next one, again, just checking in. Hope things are getting a little better for you. I'm still working on getting a legal line set up. The implication is that these are not confidential.
Okay, so then he received a letter from MCSO that said, your phone number is now confidential and arranged for privileged, confidential, client privileged communications. So
Phone
from
calls.
my no, it says this phone number is connected to that. So from my perspective, when I call someone on the tablet or when I text someone on the tablet, it goes to their phone number. So all the communications after the date of the exhibit that we put in.
Well, Lisa Ann, her appellate attorney is actually working in Idaho. She is currently being housed in Arizona. So for an appellate attorney, she really doesn't need to speak with Lori. The first thing the appellate attorney is going to do is go through the entire transcript of the trial. So appellate attorneys may not even, you know, meet with the defendant until, you know, they actually get all through an appeal or all through the case. Now, I do not like her argument. This is going to be a trial I might have to do at night when I can drink. Because I will be helping Baker with the Karen Reed trial. So we might be doing Petty Express of the Lori Vallow trial as we go through in the evenings. Because, dear Lord in heaven, this woman is going to be grating. And I'm going to need all the curse words.
In our motion, when he got that letter from MCSO that now all of your things will be confidential. Okay. Now they will be confidential. So my understanding, and I'm the only one that can waive that privilege, right?
And I think after that, when his line was approved, there were no other disclosures of messages between you and him, correct?
No, there are.
You received other disclosures of intercepting messages between you and him?
So those go up to the 24th of January?
No, the only thing I saw was up to, I think, late December of 23.
Okay, so there are confidential things that are in our communications because I was not aware that after he received that there were not. So the prosecutor who obtained these, her protocol would not be to stop and ask the court for some guidance on this, maybe do an in-camera review if she's subjecting herself to client-privileged communications, instead of reading them and finding out and assessing for herself if they're.
She's not subjecting herself. She would be inviting herself. Subjecting ourselves is what the entire audience and the court feels when we are subjected to you. So just clarifying that for the vocabulary person, you know.
There are anything in there that's confidential information between me and my appeals attorney, I have no other way to communicate with him when I'm in this incarcerated situation because I was brought here to Arizona to deal with these charges. So it is a problem. It's a problem that she took them. It's a problem that she got them from MCSO. It's a problem that she read through them. It's a huge problem that she put some of them into her motion, and now his IP address is exposed to the public, which is a federal offense. There's a lot of things wrong with what has happened here.
All right, Cash Patel, get the feds in here. Get the feds in here. Feds, come get her. Cash Patel, let's go. She's making a federal citizen's arrest. Yeah, sorry, Rachel. I know that we've got a good, looks like 20 more minutes, and I am not a night owl, so it is at 1.25 for those of you that are just coming in or filtering in. But this, oh my God.
Well, you reminded me that when his number was approved, he then sent messages from different IP addresses instead of that phone number that was privileged. So he disclosed, he's the one that disclosed or violated the confidential nature. I don't see that any of these, I'm going to call them inadvertently intercepted messages between you and your appeal attorney. I don't see that they're being used in any way by the state.
Just the state reading them as a violation of the client-attorney
Well,
privilege.
not if they're not done through a privileged setup the way that they were supposed to, which he even acknowledged.
My understanding from my perspective was that that phone number was now privileged. The way it comes to me on the tablet is I text that phone.
Oh Lord, Lori, the things that are not, you are not aware of and are beyond your knowledge. Oh, this case is going to be painful. The world according to Lori.
Phone number, or I call that phone number.
Correct,
So
if you're communicating through the phone number, but if he has it set up where the messages aren't being sent and received actually through the phone number, but
Chucky, not until they pay me. Now, if you would like to pay me NordVPN, despite the fact that I have barely any comprehension of how a VPN works or how the internet works, though God bless you, Al Gore, thank you for inventing it, I would, but Sticky Widget, this person, Lori Vallow, so Lori Vallow has already been charged in Idaho for the death of her two children, JJ Vallow and Tylee Ryan, and then the death of her fifth husband, his first wife, Tammy Daybell. She was known as the Doomsday Mom. Basically, she and her fifth husband, Chad, made their own kind of make-believe world of Mormonism that basically got to see the good and evil and chose, who was going to live and who was going to die. She was convicted on all charges in Idaho. She is currently serving in Idaho. Well, not in Idaho, but her charges in Idaho were 3 life. Oh, Mo, the foot bath. I'm going to say the purple one, but I actually can pull up what I bought. Let me go back 1 second. Okay, it is called the Foot Spa Bath Massager with Heat 2025 upgrade. So that is what I would put in. It doesn't have a name brand. Do they have AB attorney assistant? It's a standard size, so I think they would work. I don't even think soaking my feet would make Lori listenable. Now, that being said, let's see here. Lori Vallow she was moved to Arizona because before the murders happened in Idaho, she is accused of conspiring with her brother and Chad Daybell, her current husband, to murder Charles Vallow, her then fourth husband. So it is a crazy conspiracy of a case. It is ridiculous. And above and beyond all of the ridiculous things, Lori Vallow Daybell has decided to represent herself pro se. So, good Lord, just all the crazy. And Tim is right, and I think we're not supposed to call them Mormons anymore because Mormons is kind of a slur, which I did not know. So LDS, or Church of Jesus Christ of Latter-day Saints. I was like, I know it's not the Lakers. You know when your brain is not right. You know your brain is not right, but it continues to try to put up the wrong answer. So I knew it wasn't the Lakers, but my brain kept flashing up Lakers, Lakers, Lakers.
Through different IP addresses, the system doesn't know that they're privileged because they're not being sent and received through that privileged number.
But I didn't know that. There's no way for me to know that from where I am in my cell. There's no understanding for that. I assumed he was just getting them on his same phone that we were having client attorney privileged communications. And is the state giving these to Idaho? Do these get dispersed out? I would like to know that. Where are these going? They're getting them from MCSO. Is there a subpoena to get these from MCSO? Is there a warrant to get these from MCSO? I didn't see anything that warrants them getting them from MCSO in the first place.
Oh my gosh, this woman.
All right, let me hear from the state.
And I think that the state's motion really covers the law under this. The defendant and her attorney were provided with information, whether or not she understood it or not, her attorney understood that it was phone calls that were covered. So it's not just the defendant who is not complying with following the correct procedure to utilize the set up attorney-client privilege means to communicate. In this case, the state, obviously, I disclose those before I even look at them. I understand that they are statements by a defendant, and I believe that they are to be disclosed under Rule 15. And so before I even look at them, I send them to the defendant because I don't have the option of not providing them to her.
No, then
since
she'd
they have
just
been
take a lot
obtained.
of time and
I
be
think
more
if you apply
annoying.
the case law in this, the defendant cannot meet her burden to show that there's any legal advice in these messages. There's no privilege in them. The messages are asking to set up times to call and to speak.
Are the I think it's 3 messages that you included in your response, are those all the messages?
No, Your Honor, there are other messages, and we do say that tablet messages between Ms. Daybell and Mr. Jerem do not end on December 28th. They continue.
And there is privileged information on them going forward. And the state is basically testifying for my attorney now. She just testified for my attorney that he understood that that these were not privileged communications. Where does she understand that where is she testifying?
Old Line Red, when you said that she tap danced on the line of contempt, I think it's over. Judge Moe would have slapped her with contempt. Oh, and the chicken neck. I mean, the bobblehead of sassitude. I can't.
For my attorney.
Well, I think because the context of the messages say, I'm trying to schedule a time and I'm trying to set up a confidential line, meaning
That was
this is not
before.
confidential.
That's right. He said it wasn't confidential before MCSO gave him a letter saying your phone number is now confidential. Your phone number now has.
Okay, I'm not going to keep rehashing this with you. The fact that he's using different IP addresses and not messaging through the actual phone number that's protected, I think is part of the problem. So if he's not using the program correctly, that's.
Oh my gosh, if anyone can get me a clip of, oh no, you know what? I think NBC or the Olympics struck down every copy of that Australian breakdancer, but I think we're going to need a breakdancing over the line of contempt stinger for this case. I will start. Let me write that down in my stuff not to remember portion of this notepad. So we can get a breakdancing over the line of contempt stinger going tomorrow.
It's an issue you need to take up with your attorney.
How is
This
he
would
using
be-
it incorrectly?
I just told you. He's not messaging through the phone number. He's using different IP.
How can
addresses.
you message other than the phone number? I don't understand that.
I don't understand that either, but if it was from the phone number and it's for his cell phone, for example, it would be the same IP address for each communication. There's like 4 or 5 IP addresses.
Where are the IP addresses coming from? They're given to you by the state?
They're right there listed on the messages
I'm just saying, where are they obtaining those from?
from your attorney's messages to you.
From MCSO?
Yeah.
Did they get IP addresses for every single person of every single message communication on the text from MCSO?
Well, it's listed on the messages, so I assume so. It says Craig Durham, and then under it is the IP address from the device that's being used.
Okay, and then Ms. K is reading all of these messages and they're not privileged. Is that what you're coming to?
They're not privileged if you're not using the program or your attorney's not using the program correctly. Okay, they're still not going to be allowed to use any of these messages. What I'm saying is they're inadvertent disclosure by MCSO because someone's not using the program correctly doesn't mean that they had bad faith in how they got them. They made
How is he using it incorrectly?
I don't know how else to explain it to you. I've told you 5 different times now. So he's not messaging with the phone number. He's messaging from different IP addresses.
Okay, can I ask if these messages are being disseminated anywhere to Idaho, to the prosecutors in Idaho? Because it's definitely affecting my appeal if that's the case.
I don't know.
Have not been sent to anyone other than the defendant, Your Honor.
All right. So there was some communications I find that were intercepted between Ms. Daybell and her attorney. The state's not to use those communications. They're not to disseminate those communications, but I do find that they weren't purposely sought out by the state. And that dismissal isn't the appropriate sanction if there is an appropriate sanction. It's order denying the motion to dismiss for violation of confidential communication. All right, then we have defendant's motion to dismiss for prosecutorial misconduct dated March 21st. Let me get that. And the state's response. The motion to dismiss for prosecutorial misconduct was filed on March 21. The response, I don't see a date on the response, but I do have the response. Did you get that response?
Old line red, you win the internet with that. I used to know someone like Lori.
Daybell, did you get
That
that
person
response?
was a
I did, Your Honor.
4-year-old at the time.
All right. So your prior attorneys had, actually, let me back up. The state filed a motion back in, I think it was September of 2024, asking the court to preclude your defense team at the time from making public records requests through Gilbert and/or Chandler police departments. I denied the state's request, saying that the defense is free to do their investigation and make public records requests through appropriate means. So that's part of your complaint, that they didn't provide those public documents to the defense. That's sort of a civil issue, I guess, but let me hear your argument on that.
That isn't really the complaint itself.
That's your first paragraph.
I know, but the complaint is that,
I'd like to take each allegation and deal with them one at a time. That's
I
your-
understand
that's
that.
your first
My
allegation.
complaint is the interference by the state, Ms. K in particular, in stopping that and interfering with us trying to investigate and do our own investigation. It is a violation of the constitutional right and due process. And she did do it, and she did do it purposefully. And then after she did it, and we weren't allowed to have anything from either of the police departments, then she filed her motion. And then later, the day that I was Rule 11, that is the day after when you said that you denied that motion. So I don't know what she did or what she said to Chandler and Gilbert to stop them from giving us any information. But as soon as we put in a request, we were cut off. No information. You can't have anything. That's when I was trying to, the big video that we're trying to get in Gilbert, that's what I was trying to request. I tried to request that myself because I would have my investigator to go and explain what that was and why we didn't have it. And so we were precluded from doing all those things by the state. They should not be interfering with that. That's one of the reasons why everything has taken so long. We haven't been given things we've asked the state for. We haven't been given them. We tried to get them from Chandler and Gilbert. We can't get them from them. She's stopping us from getting from them. How are you supposed to put together a defense?
So when your prior defense counsel put in that request back in September,
To be fair, Chucky, I would not have known that, but apparently the IP on your phone or electronic device is not permanent. It can change every time you connect to the internet. This woman should not call Best Buy for IT advice. No, probably not. That being said, I wouldn't have known that either.
the state says that they obtained those information and gave it to your attorneys on October 1. So why are we waiting until March to address this if you had an issue with that?
I have had an issue with it the whole time.
But why didn't you file why didn't someone file a motion back in after, December, November, January, February, saying they had an issue with this?
I did. These are in my motions to you for specific discovery. I discussed this exact problem.
Okay. Well, now you're saying it arises the prosecutorial misconduct.
It is.
This is the first I've been made aware of that, as far as I know, that the police department never honored the public records request. If they don't honor a public records request, there's a process to go through regarding that.
Which is what?
I'm not going to give you legal advice. All right. Your second allegation, the prosecutorial misconduct, we've already kind of dealt with, that she distributed the state distributed attorney-client privileged communication. We've discussed that. The next one is legal advice to defense witness Nate Eaton. We've somewhat discussed that, but I think their motion, the state says that they simply notified him that he would need to be served with a subpoena to have to appear in court. So how is that improper?
It's taking her word for that that's what happened. She's not under oath saying that that's what happened. Nate Eaton's not here to testify that that's what happened. They're the only two parties that are there to say that.
Jennifer Swift, how come some cameras are face forward and other trials aren't? That might be at the discretion of the judge. It might be logistics of how the courtroom is set up. I do know that Lori did get the cameras successfully thrown out of the Idaho trial because they were constantly focusing on her face, and the defense attorneys were successfully able to argue to the judge that that was discriminatory or prejudicial. Now, that being said, these cameras might be positioned the way they are right now to kind of preclude that. It seems like the attorney or the judge is being very cautious with the media coverage of this case, as far as having a 30-minute delay from the live feed to what the jury pool is allowed to broadcast. So that being said, those are the only answers I can give you of some of the things.
That is what happened. So that is my problem with it. I would like for one of them to get on the stand and say exactly what happened in that conversation and that she wasn't giving him legal advice. How do we know that she wasn't? It's a very curious situation that he called her and then he writes in his motion this statement that obviously comes from Ms. K. She seems to be a clear attempt by Ms. Abel to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. We also don't know if he told her, don't come to the March 18th hearing because that's when they're going to serve you with your subpoena. So all these things come from there, and we don't know who's saying it. And you're just taking her word for it, like you took her word for, oh, there's only 6 emails and there's no other emails. You're just taking her word for it as an officer of the court, and I think that she should have to be sworn in.
Well, you want me to just take your word for he must have gotten these things from Ms. K, okay? Just because his motion says he thinks that you're noticing him as a witness to keep him out of the courtroom? I don't know why you take the jump to that is coming from Ms. K as opposed to his own volition. He also hired an attorney that said the same thing. Even if she had said you need to be served with a subpoena to have to show up in court, that is not an ethical violation.
Well, giving legal advice is an ethical violation. Is that correct?
Stating what the law is not an ethical violation. If she said, I don't think you should show up at court, even if you're subpoenaed or something like that, that could be an ethical violation.
And live in life. Well, that is good. I'm glad you got a nap, you know, especially with insomnia and everything. You know what? If my voice was mellow enough to put you to sleep, that's also a compliment. And Old Line Red says officers of the court are generally taken at their word, Lori. They're pretty severe consequences for lying to the court. Yes. You know, you can lose your, basically your profession. You can get disbarred. So yeah, it's kind of a big deal. That's why they are considered, officers of the court.
Violation, but we don't have that.
How do we know we don't have that? That's my question. How do we know what went on in that conversation if it wasn't recorded? Aren't witness
You can
interviews
interview him.
recorded?
You can interview Mr. Eaton. Your investigator can interview Mr. Eaton. So when and if you get that information from Mr. Eaton that something nefarious happened in that conversation, bring it up then. But you're jumping to conclusions. You have the right to interview any witness, okay?
not a witness anymore because you just precluded him?
All right. You can interview him. You can have your investigator interview him.
So
That's-
even though he's not a notice witness now, we can still interview him and try to find this information because we can't get it now? Is that what you're saying?
Sure. Have your investigator call him. Ask him about the.
How is this not contempt? Oh, awesome sauce. That'll be great.
Conversation. At this time, I'm going to, based on just the pleadings, I'm denying the motion to dismiss for prosecutorial misconduct. Of course. All right,
Oh, hell no, this heifer did not just say, of course, into the microphone like she has something to actually be sassy press about. Oh, hell no, madam of the, I did not think that this thunder cow is allowed to talk. Hell no. Yeah. Oh my gosh, this hearing, yeah, oh Lord, is this going to be a ish show and a half? I don't know if this, Lori, do you need a Snickers? Now listen, I understand that you and I, but you more so than me, are a woman of a certain age. And, you might need a Snickers as those hormones start running away from your body as God stills your youth and your looks. That being said, do you want a Snickers, Lori?
.609 motion. The state's alleged a total of 7 felony convictions in the state of Idaho. Under Rule 609, the court finds that limiting the number of convictions and the nature of the convictions to be appropriate as to not be overly prejudicial. There is an interest in allowing a jury to know that the defendant's been convicted of at least 1 felony. But let me hear, I'm inclined to probably limit it to 2 felonies in order that they be sanitized. Does the state want to be heard on that?
Your Honor, I do believe that the court should allow for at least 3. There are multiple dates and multiple victims in those and multiple different distinct incidents. And I believe that it would be appropriate to, when we're talking about the credibility of the defendant, to allowing in 3 of those.
Holy crap. How many license plates to make $5 in prison money? Because, wow. I guess I'd become really slender in prison.
I looked at the date ranges and I looked at the actual counts, and some of the counts, obviously the laws are titled differently in Idaho, but there's a couple of counts that specifically have what I would call dishonesty built into the name of the conviction, the first-degree murder and grand theft by deception. Those are counts 1 and 3 specifically. And again, these only become relevant if the defendant chooses to testify. I did read the defendant's response asking that all of them be precluded. Let me hear from the defendant.
Oh, Lord.
1 second, Your Honor.
Jesus will exonerate me from my Idaho prosecutions. Ma'am, let me break this down for you, Lori. Come here, come here. Come into the bosom of Mo. Look, I'm not playing for that team. Don't flatter yourself. Anywho, ma'am, let me break this down for you. On behalf of every American, and I do feel that I can speak on behalf of every single American when I say that we could give 2 flying fucks what you're going to say or do in this trial. Like, I don't care. You don't have to cover your mouth. Like, I actively don't care what you're going to do in this trial, other than and beyond the fact that I want to see a flaming dumpster fire. I don't care. Like, I don't think anyone's going to try to, look at this and figure out, what your strategery is. No one gives 2 flying F-bombs what your strategery is going to be, ma'am. Yeah, when Lori Vallow makes me wish for Daryl Brooks. A sentence I never thought I would say.
Your Honor, I haven't had a time to, I wasn't planning on talking about the 609 today, so I'll just refer to my reply.
Well, we can
Same
table it
seas.
till later in the trial because, again, it doesn't become relevant unless you choose to testify, but you know my inclination and what the state's argument is.
Okay.
This morning I handed each side proposed preliminary instructions. We don't need to discuss those now, but depending on tomorrow how far we get in the jury selection process, maybe you can be prepared to tell me if you object to any or if there are additions or corrections that need to be made.
Oh God, Lori and opening instructions.
All right, I think that's going to be it for today, but let me check with the state. Is there anything else we need to address today?
Puddletown, I see 2 sides to it, and I'll give you both sides. I see the side of what you're saying. So what's the point anyway? She's already got like 3 life sentences. Does Arizona have capital punishment? I do not believe so. Because remember Sal answered that yesterday. They got rid of it right after the Jodi Arias trial, and they dropped that charge for her. Now, so I see I see your point that she's already got 3 life, sentences. Why should we charge her for this? Now, I will say that there are several reasons that Arizona is charging her with this. Number one, Charles deserves justice, but also this is a fail safe. While I believe that the state had a fairly airtight case against Lori for all of the Idaho cases, since they were tried together, should there be some sort of appealable issue in that case, this is insurance that she even should, Jesus himself come down and say, Lori is innocent of all things in Idaho. She will still be in prison in Arizona. So those are the couple of reasons, that I can see as to why they would go ahead and charge. Now, I do think that, Kay Woodcock might feel like she got the justice, in part because of JJ, but I think that it's right that they go ahead and charge her with Charles. I think that Charles, beyond anyone else involved in this case, tried to sound the alarm about Lori, about Chad, about them, having, an affair, about, scary things that were happening, very dangerous, kind of divorced from reality behavior that Lori was exhibiting. So, if for no other reason than to vindicate and find justice for the first person to sound the alarm on these murderous dingbats, then that is fine. And also, Arizona is their own state and they're allowed to charge what they want to, assuming Idaho agrees.
I think just for the record, Your Honor, in terms of allowing in witnesses, the gallery, I think that you had indicated you would reserve 1 row for the next of kin.
Yeah, let's discuss that. We're going to put up signage after we complete jury selection. So the first row on both sides behind defense counsel and behind the state will be reserved for immediate family members, next of kin, those sorts of people, relatives. The very last row on both sides will be reserved for media. And then the middle rows in between those two will be kind of a first come, first serve general public viewing area. Any questions about that?
I do just want to make sure that, assuming we are leaving on the defendant's mother, father, sister,
Well, if they're potential witnesses, they won't be in here.
the state will be invoking the rule of exclusion.
Do you understand that, Ms. Dabo?
I do.
All right. So as long as people that we haven't already addressed other than Mr. Eaton remain on the witness list, the rule of exclusion would be, in fact, it means that they won't be allowed in the courtroom except for your investigator can be in the courtroom. And they're precluded from talking to any.
Old Line Red brings up a point I had totally forgotten, but Brandon Boudreaux is also a living victim who still resides in Arizona. And they tried to do the same to him to get his life insurance for Lori's niece, Melanie. Her last name was Boudreaux. Then she married someone sort of within the cult. I don't know. So I don't know what her last name is. Yeah, Chucky, I don't know how they do with that. I can't type that fast or well or listen to this much boring stuff sometimes.
Anyone about their testimony or other testimony until they're released as witnesses. Anything else from the state for today?
I don't believe so, Your Honor.
All right. Anything from the defense for today?
A couple of things, Your Honor. We need to discuss
how the division would like the media exhibits.
What?
How the division would like the media exhibits, if we're presenting recordings or audio, individual flash drives for each exhibit. there wasn't.
Depends on how you're going to present them, but I would say, yeah, probably one flash drive per recording or exhibit.
And then I'm guessing 3 copies, one for state, one for.
I don't know that you need copies if you've already disclosed it to them. Just tell them what it is when we're marking it, and tell the clerk what it is with the description, so it's clear on the exhibit list which exhibit is what.
One more thing, Your Honor. I wanted a clarification in your minute entry dated the 25th regarding the defendant's motion to remove restraints. So my understanding when I read what was from MCSO, and then you put in here, however, at the sheriff's discretion, 1 or more armed sheriff deputies may be positioned near the exits. So what their recommendation was the minimal amount of restraints, meaning if there was going to be an armed guard, then they would not have to do the belt. So I was confused by and wanted a clarification on what you were actually ordering, because the DOs had a question about it with me this morning. So
I ordered that you don't have to wear the leg restraint, but that you do have to wear the rack belt, because that is not going to be visible to the jury. The leg restraint's a little more cumbersome and visible, and since you're representing yourself and you're going to need to approach the podium and those sorts of things, I ordered the removal of the leg restraint. You will, though, wear the rack belt. And then I said it's up to the sheriff's office if they want to. They can position a couple deputies in the back if they want additional deputies.
well, their recommendation was that you wouldn't have to use the belt at all if they had the armed guard.
I read their response and their recommendation, and that's my order,
So what is it exactly?
that you have to wear the rack belt but not the leg restraint.
And that they will or will not have armed guard?
It's up to them.
Okay.
I believe that is a shock belt. So I guess it's called a rack belt. So I guess it's a shock belt. And listen, Lord, I don't ask you for much, but I think to heal America, the world, nay, the universe, we didn't get to see Daryl Brooks shocked. Could we at least get to see Lori Vallow shocked? I'm just asking for a friend. I think she's planning on, I don't know if she would be able to stop herself if Kay said something that ticked her off. I think Lori holds tremendous, and I mean like beyond the amount I hate Kevin Spacey, I think Lori holds tremendous resentment and rage, festering, simmering rage against Kay Woodcock, the person who was, exchanged her for the beneficiary of Charles's, life insurance. So I think if there is anyone Lori blames for her downfall because she doesn't blame herself, it is Kay Woodcock, because Kay Woodcock was persistent in asking where JJ was. Kay Woodcock was the beneficiary of Charles's life insurance, and Kay Woodcock would not give up the search for JJ, leading to her and Chad's, downfall. So I think that just like Daryl Brooks had Erica, I believe that Lori has Kay Woodcock, and Kay Woodcock is in her sights, and I hope that they have some deputies close to her, because I do not foresee her having the emotional self-control and self-restraint to not physically attack Kay if Kay says something that she takes as disrespectful. I mean, that's just my thing.
All right, so tomorrow we're going to start at 10:30 with going through the answers
Oh, no. Yikes.
on the questionnaires that the walk-in jurors will fill out in the morning. And then in the afternoon, we'll have in-person voir dire of those potential jurors. The court's going to seal the FTR tomorrow for the portion of the in-person answers of the jurors, which should be from 1:30 on. All right, we'll be at recess.
Oh, and Kiwi Green, are you okay? Sorry, my brain.
Fox 10 investigator Justin Lum here.
Oh, okay. No, I'm not, because local news stations are the worst at copyright claiming you. So no, no, no. We did not see that. And let me see who I can send you guys to. Part 3, edit video. I am. Okay, where am I? Customization. It's like, I know I have this thing, I'm being a smart pants. Oh, Megan Fox. Well, I am a genius. All right, well, you guys go give Megan a bunch of hilarity and fun, and I will see you guys in the morning. I'm going to go run and make sure that everyone turns in their pads so they go to sleep, because my boys like to keep their pads on all night and then wonder why they're grumpy in the morning. Yay! Absolutely, White Rabbit. Kay is a hero of epic proportion. Kay should have the remote to the shock belt for her own protection and a little justice. I approve that. I will see you guys later. Give Megan some love for me. I am going to go make sure that pads are rounded up. I might be in chat with Megan later, or I might not be, because I'm making sure that everyone's homework is done too. Bye, you guys.